You're facing up to 6 months in jail and or a $2,000 fine. You're also charged with theft, a Class A misdemeanor where you're facing up to a year in jail and or a $4,000 fine.
Law enforcement officer spoke with the complaining witness who stated that on April 2nd, 2025, he parked his truck in his company's parking lot, locked the truck, and when he returned the next day, his tailgate was missing. An employee of the complaining witness searched Facebook Marketplace and found a tailgate that matched the complaining witness's stolen tailgate and had recently been published. The law enforcement officer executed a sting operation to purchase the tailgate from the defendant, the seller, on Facebook Marketplace. He paid the defendant $140 for the tailgate. The defendant was subsequently
arrested. All right, folks, get ready. This one's a roller coaster. We're talking serious charges, property damage, and stealing a truck tailgate in broad daylight. Here's what happened. On April 7, 2025, a man parked his truck in a company lot. By the emo, next morning, the tailgate had mysteriously vanished, taken quickly and confidently. But things took a turn when an employee spotted what looked like the stolen tailgate listed for sale on Facebook Marketplace. That tip launched a sting operation by law enforcement. This wasn't just bad luck, it was a deliberate act, and now it's a full-blown criminal case.
The complaining witness stated the price to replace the tailgate was $1,117.65. The defendant stated he buys the tailgates from a friend for $75 and resells them for typically $300 to $400.
We have him taking the actual tailgate, right?
Yes, Your Honor, that's what it says. Well, it has him as the seller of the tailgate.
Yeah, I didn't take the Your Honor.
Stop. Don't say anything. You have the right to remain silent. Exercise that right.
Yes, Your Honor, it has him as the seller and that it was recently published 2 hours ago on Facebook Marketplace. But those are the facts as far as the dim summary goes.
It says here that this defendant did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, namely a tailgate.
Let's get straight into it. This case is all about the hustle, but not the legal kind. Cops went undercover, posed as buyers, and met up with the Facebook seller. They handed over $140 cash, and just like that, boom, he was arrested on the spot. The man in court today is that very seller. Turns out the stolen tailgate was worth over $100. And here's the kicker. He admitted to buying tailgates from a friend for just $75 and flipping them for as much as $400. Sure, it looks like a business, but it reeks of a shady setup. And in this courtroom, it's not about theories. If you're selling stolen parts, you're in deep, whether you meant to be or not.
Owned by Jonathan Smith. Did he take the actual tailgate?
Your Honor, there are no facts alleged in the DEMS that he knowingly took the actual tailgate. However, the tailgate was in his possession and under his control.
Sure.
He was the seller on Facebook Marketplace. There's no information in the DEMS, though, that represents that he was the actual individual that stole the tailgate. In fact, when the officers interview him, he says that a friend, he buys the tailgates from a friend and then resells them on Facebook Marketplace.
Are we to assume that he knows that they're stolen? No?
No sugarcoating this. His defense? I didn't steal it. But here's the truth. You don't need to physically rip something off to be guilty of theft. He had the tailgate, he sold it. That's control, that's illegal possession. And the timing? The Facebook Marketplace post went up just 2 hours before the sting. That's not luck, that's a setup. All police had to show was that he knew it was stolen. And according to reports, he admitted just that. Game over. That's probable cause. Clear and simple. The judge isn't here to debate it, and the law doesn't bend. In cases like this, you're either running the game or you're getting caught in it.
He's charged with theft, right? It's a specific intent crime. So if he's selling stolen property, somehow there has to be evidence that he knows that it's stolen. How do we know that he knows it's stolen? We don't operate on hunches.
Your Honor, there is also an allegation, or it's alleged that the defendant told the law enforcement officer that he was aware the tailgate was stolen.
Well, there you go. Okay.
Thank you. It's my fault.
Mr. Aguilar, I'm going to find if there's sufficient probable cause to go forward in the theft case. What about the failure to stop and give information?
Failure to stop and give information.
Let's see. We need to do probable cause on that one as well, please.
and it's not looking good. This time, the charge is failure to stop and give information after hitting a metal gate at an apartment complex. A witness saw everything, snapped pictures of the car, the driver, even the passenger. Plates were traced and boom, same guy. Police later found the car parked right outside his house, front end smashed like it ran into a wall. When questioned, he claimed he loaned the car to some guy he barely knows from Instagram. Instagram? That excuse doesn't hold water. In fact, it syncs faster than stolen parts in a police database.
Good, Your Honor.
Yep.
The law enforcement officer was following up on this case in the original report. The defendant's vehicle struck a metal gate at an apartment complex. A witness looked out her window and saw the suspect vehicle and photographed the driver and passenger as they exited the vehicle. Law enforcement officers ran the plates and had the vehicle and owner information. The law enforcement officer later observed the defendant's vehicle in front of the residence. The vehicle had significant damage to the hood. The law enforcement officer made contact with the driver, the defendant. The defendant was ID'd to be the vehicle owner. The defendant stated he loaned his vehicle to an acquaintance he only knows through Instagram. The defendant showed the law enforcement officer the man's Instagram named Go Get a Veil.
Here's the twist. He tries to shift the blame. Tells officers the guy behind the wheel was someone from Instagram named Go Get a Veil. No full name, no details, just that this mystery man needed the car to pick up a girl. Police wait for more info, but he never calls back. Total silence. Then the officer reviews body cam footage and lines it up with the witness photos. And it's a match. Same guy, same face. Turns out he didn't loan the car. He was behind the wheel. The evidence piles up fast. Damage to the apartment complex? $2,000. What started as a weak denial has now turned into a full-blown mess of bad. Choices catching up with him fast.
The defendant claimed that this man needed to borrow the car to pick up a girl. The defendant stated he would obtain the man's real name and provide it to the law enforcement officer by the end of the day. The law enforcement officer was not contacted by the defendant again. The law enforcement officer took a still shot on his body-worn camera of the defendant during the conversation. The law enforcement officer later compared the photos and saw the defendant was the same as the photo from the reportee. The law enforcement officer attempted to contact the defendant and could not. The apartment complex's estimated damages are $2,000.
Got it. Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward on both of your cases. Can you tell me if he has a license to drive, please? Texas driver license.
Now, things get serious. The judge doesn't mince words. One wrong move and the bond is gone. He makes it clear this case isn't just about property damage or stolen parts. It's about public safety. If the defendant messes up again, tries to contact witnesses, drives without a license or insurance, or racks up any new charges, it's game over. No second chances. He'll be back behind bars before he knows it. This is Texas, and the court isn't playing. You can't break laws, profit off stolen goods, and expect to walk away like nothing happened.
John, can you check that on Aguilar?
Don't. I know that you are itching to say stuff. Don't. You have the right to remain silent. Exercise. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. So just now's not the time to fight your case. You will have the opportunity to fight it. Just now's not the time. I want you to understand, Mr. Aguilar, I will do everything in my power to protect my city at all costs, including property. And if I find that you're a danger to my city, I'm going to lock you up and I'm going to make your bond so high, you'll have hair falling out.
Yes,
do
Your Honor.
you understand?
Yes, Your Honor. Your Honor.
Tell me what time of night was. Do we know the theft of the tailgate? Was it in the middle of the night?
So it was reported around 5 p.m. That's the only information we have, Your Honor.
Time for a reality check. The judge isn't here for excuses. He lays it out plain. No contact with the victim, no driving without insurance, and no new trouble. Break any of these rules and the bond shoots up to $15,000. Can't pay? Then he's not going anywhere. It's not just jail. It's life on hold. The case stalls, the clock stops, and everything stays stuck. The message is clear: play games with the law and be ready to face the full weight of it. This courtroom doesn't bluff. Every move is watched, every lie gets exposed, and the truth always wins.
I'm ordering you as a condition of your bond not to pick up any new cases, not to have any contact with the complaining witness in the theft case, not to go within 200 feet of where they live or where they work. Do not pick up any new cases. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, and that is also a bond condition. If I find that you're driving without car insurance, likewise, you will go to jail. That's it. If I end up revoking your bonds for one thing or the other, they're probably going to end up around 10, maybe 15,000. And if you don't have anyone to pony up that kind of money, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay, we are going to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. After that, you'll be free to go. Don't be a danger in my city. Do you understand me?
I understand.
Final warning, loud and clear. The judge gives him a small window to hire a lawyer, but makes it crystal clear. This isn't time to stall, plot, or disappear. Don't be a danger to my city, he says, voice firm and cold. And that's the end of it. Not every case gets this close of a look, but when you mix reckless choices, online selling of sketchy parts, and made-up stories about strangers from Instagram, you're not just crossing the line, you're daring the system to strike back. This isn't a TV drama, it's real. And this is the price of playing dirty in today's digital world.